Oh, that's a good sign. Okay, do we have Tuesday tips up there?
Yes, we do.
Oh, that is good to hear. All right. Well, the topic today that we're going to be looking at is wills and also equitable versus equal. And my name is Marcia Getting. I'm the Family Economics Specialist with MSU Extension. And both Emily and I are a part of the land grant mission where we take the university out to the people. And this is a fun way to do it with doing webinars. So we're excited. And last time I just took a look at where a few of you were from, and it was kind of fun to put it on the map and get an idea that we've got some folks in Glasgow and we got some up there in Liberty County there. So it's exciting and we welcome all of you. I know that we've got a few out-of-staters as well, so we extend our welcome to you. Now, just a reminder, when you do have a question, do take advantage of that chat panel. That's how we're able to look at those. And then later, what we'd like to do is be able to connect some of you, because what happened is maybe there was a question I didn't answer fully enough. And if we could figure out who did that, we would send an email to you. The other thing we're going to do is remain in the chat room for 30 minutes after, or chat room, this room that we're in, to try and answer questions that you have. Now, those of you that are new may not know that one of the things I like to do is use wildflowers as triggers to help remember things. And so I thought that might be fun to use with my audiences. So here's an example of a trigger that is a flower. And if you look at it really closely, you can see a couple of eyeballs there and a couple of ears. And what we've got is a steer's head. And what we're going to do with the steer's head then is, hey, we're going to steer you to consider whether to divide your property equally or equitably. The other thing I'd like to do during this session is steer you to the benefits of having a will. And remember, a will can only handle the property that you have that is titled. Okay? So what do we've got here? Well, this is a plant that I happen to see in Botswana, and one of the things I do is carry a camera and take a picture of every flower. And this wasn't a flower, but I looked really close at it, and I saw, that's a heart. So who knows what plant it really is, but I'm calling it the Botswana heart plant. And I'm wanting to encourage you to have a heart and decide about who are going to be your beneficiaries. Now, if you're married, it's probably going to be the spouse. And if you've got children, those are possibilities as well. And how about the grandkids? But maybe you were like me, I wanted my parents and my brothers or my sisters in this case to be able to inherit property. There may be other relatives in your life that you would like to recognize. How about some of those nonprofits and charities that are just next to your heart and you would like, like a community foundation that is helping in the community? How about some friends? Well, some of those friends would be good to leave. And how about some of those colleagues that you work with? So that's one of the first decisions to think about as you're trying to write a will and decide what it is that you want to accomplish. So my reflection for the Botswana heart plant is make that decision about who you want your beneficiaries to be, and then also realize that through time, circumstances change. And just because you wrote a will 20 years ago doesn't mean that that is the will that is appropriate for you today. Now, this particular flower has a lot of names, but the one that I like is Chocolate Lilly. And it actually reminds me of a time when my grandma had a Hershey bar. And grandma was going to let my sister and I divide this chocolate bar. And I said, oh, grandma, I'd be glad to do that. And grandma was smart. And she said, sure, Marcia, you can do that. But if you do, Donna gets the first choice. So what do I come up with is equal. And that's another decision, then, that you're going to need to make about this equal versus equitable or fairly. Now, most all of us have a term in mind when we think of equal. It's either the same size, it would be the same dollar amount, maybe it would be the same amount of land, Or if you have two vehicles, maybe it would be one to each if you had two children. But when we get to equitable, I decided, well, I have a definition, but what do they tell us in the dictionary? So I went there and it said, dealing fairly with all concerned, fair and impartial. And as I looked at that, I go, huh. And as I've shared that with people at meetings, one of the things I find is that fair is in the eye of the beholder. I don't know how many oftentimes we might have said through our lives, oh, that's not fair, or this is not fair, but it's really in the eye of the beholder. So I'm rather curious right now. You've got a poll there. And at this point in time, what are your bequest intentions? Are you going to be plan to distribute your assets equally or equitably? Now, this is one of those questions. There's no right or wrong. It's just in your mind, how do you want to split the assets that you have? And maybe there's a lot, and maybe you don't have very many, but how are you going to do it? Equal or equitable? Oh, and don't forget to hit the submit button. It's way down there on the right hand side in the corner. So what do we got, Emily? How are people going to divide their property? Okay, we'll take a look at the results here so that I can see them. And it looks like we've got about 44% that are saying equitably, and we've got 22% that say equal. So this is a very interesting part to start from as we look at this. So let's look at equal. You know, we only had about 22% of you thinking about that, but this is what Montana does, as well as parents may wind up doing in their will. If we say equal, then we're going to give each child a third, a third, and a third. But what that may not take in consideration is the family circumstances, because we've got one child here with Down syndrome, we've got one that's an investment advisor, and maybe we have a high school teacher. And maybe fairly to these parents would be to give it to all three. But if we did that, what we'd want to do for the Down syndrome child is put it in a trust. We could do a special needs trust to make sure that that child is provided for. And it's up to you. It's your assets. You have earned those. You have a right to make that decision. But sometimes people or parents that try to do equal find, oh man, it's not working out too well. You know, you may have a ranch, you may have a farm, the cottage or the lake house. Could they really own this equally and be able to reach decisions about such things as, well, should we put cable TV up there? Should we replace the roof? What kinds of things would go on there? And then what if you have one kid that decides they don't want any part of this operation or the lake cabin, and what they want to do is sell out their interest? And then that forces the other two to say, oh, we've got to buy them out, but gee, what if they don't have the money? And then we may have a couple of individuals that go to the cabin, and those are the ones that have planted trees, they've taken care of the place, they've actually built onto it, even though it belongs to the whole family. But will mom and dad recognize that contribution? Well, we'd have to ask them. Now, it could be we've got a situation like this. This is sort of a drawing that I've used in some of my other programs, but I'm going to say we've got grandpa and grandma up there at the top, and grandma is the one that lived the longest, and so therefore everything was in her name. It was sole ownership. So she could write a will, and she could decide what I'm going to do is treat all of my grandchildren equally. So that means a sixth to each one. Now, on the other hand, maybe she decides she's still going to write that will, but she's not going to give it in equal amounts to all of the grandchildren. Here we have an example where grandma decided, I'm going to leave half to one of the grandchildren and a fourth to the other two. Now, if we were in a real meeting here, I'd be asking you, why? Why would grandma do that? And I've done that at a couple of meetings, and I've had such fun responses because some will say, oh, that child, the grandchild that got a half, she was the favorite, or liked her better. Well, yeah, maybe that's true in this case because this is the only grandchild that actually took time out to write grandma now and then. She, yes, wrote not an email or a text. Yeah, she wrote a card. She would write birthday cards. And so, yes, this particular grandma decided this is the way that I'm going to make that division based on what I feel they treated me. Now we've got a different situation where the mom, in this case, left it all to the daughter. Now, in your mind, think, why would mom leave it all to just one daughter? Well, how about this? It's consideration. It's the daughter that has provided the care that has allowed this mom to be able to stay in her home and not have to go to a nursing home. So in this case, the two brothers agreed completely. They were fine with that decision of mom's because they realized they hadn't really made contribution that they could have. On the other hand, grandma could have written a will and she could have left this to her nonprofit. So maybe it would be to the Montana 4-H Foundation for use in the county where that mom came from. So we might say, okay, we're going to use that in Liberty County, for example. So my reflection from the Chocolate Lily is really, if you've got somebody else involved in your life, decide how you want to distribute your property. Think about that equitable and what equitable means to you and your family situation. Now, these happen to be baneberry flowers, and those are followed by baneberry berries, and we should see these in another month or so. Have you heard this phrase? So-and-so is the bane of my existence. Well, look at this will. Here is a will that a mother wrote, and she said, my only son David is not to receive a single penny from my estate for reasons well known to him and to my family and friends. And for the further reason that during his whole lifetime, since he attained age of majority, he has been the bane of my existence. He has been disobedient, ungrateful, and a constant source of humiliation, anxiety, and sorrow. Whoa! Would you like to have a will written like that? Now, most attorneys are going to discourage you from doing something like this, but this mom was very precise. She said, that is what I want to say, and so she did. So I've got a question for you. Do you have a written will? Yes or no? So there's an easy one. Yes or no? Okay, Emily, what do we got there? Okay, 36% say that they do. We've got 33% that said that they don't, and then the rest we don't have an answer. So that's pretty good because when we look at nationally, there are 7 out of 10 that don't have a will. Okay, that's about 70% there. And basically, we know what a will is. It's just a written document that describes how the maker wants to have property distributed. Okay, that's basically what it is. And Montana doesn't have very many requirements, but they do have one. And that one is you must be age 18 years or more of age older. Okay? The second thing is that you must be of sound mind. And what that means is you know the nature of your property and know those to whom you would leave your property. Emily, I got a question for you. Is a small photograph of me showing up anywhere?
Yep, at the top of the screen.
Aha. Okay. Well, I'm not seeing it for me, so I thought maybe I'd shut myself off. So thank you. Okay. So here's an example of Dad's will. The attorney said, Dad said, being of sound mind, I spin it all. Now, wouldn't we like to come out even and do something like that? Now, another question for you. Does a will have to go through probate to be declared valid? Does a will have to go through probate to be declared valid? So don't forget, hit submit button. And remember, you have a 50% chance of being right on this one. Okay, Emily, what do you think? Okay, we've got people saying yes, 9%, no, 58%. Well, this is one of those questions that I just feel very good that I've included because, yes, a will, just because you've written it, doesn't make it valid. It has to be submitted to the clerk of the court and therefore go through a process that we call probate to validate the will. Now, this wouldn't be true if you have all non-probate property. And in prior sessions, we've talked about payable on death designations, transfer on death registrations, etc. Those are non-probate property. But if you have solely owned property and have tenancy in common property, then your will has to be declared valid in court. Now, we've got a situation where Montana is one of the few states that allow a holographic will. And what that means is everything is in what we call the testator's handwriting. So testator is a person that writes a will. So if you have a handwritten will, no witnesses are necessary. But if you have a formal will, one that you type up, one that you use a computer program, or even one that you fill in the blanks, those all have to be witnessed. Okay? So let's look at a man that did this in Western Montana. What he did was write his will on motel stationery. It was in his own handwriting. Now, the question is, did the court declare the will to be valid? Yes or no? So another one, 50% chance of being right here. And don't forget to hit submit. Okay, this will be an interesting one. So let's look at the results. Okay, 73% of you are saying yes, and we've only got 6% that said no, and then we do have 21% that said no answer. Well, this happens to be another one that I'm glad that I asked you about, because what we discover is the judge rejected this particular handwritten will because he said everything was not in the testator's handwriting. And I know you're probably out there groaning, but that's really what happened. You see, the judge looked at that handwritten will, and he looked at the top of the letter or of the paper. And if you look at motel stationery, what else is on there? Well, maybe a photograph of the place, maybe the mailing address, the phone number, now it'd be email. The judge rejected it for that reason. So that's why it's important that you know what the rules are so that you can follow those and not have your will rejected and then it goes back to the state of Montana rules. So how do you change a will? You've got one that's 20 years old and you want to change it. Well, one way is to just say, revoke the will. You revoke it. You say, I don't have that one anymore. And one way then is if you write another will one of the first paragraphs in there or provisions, the attorney will say, I hereby revoke all prior wills. You know, you will sign to that effect. And another thing is a codicil. And a codicil used to be more popular than it is now. A codicil simply goes in and you change one paragraph, okay, or two or three, whatever. But in this day and age, it's just, you know, wills happen to be on the attorney's hard drive and you want to come in and change it. Probably what will happen is we'll just do a new one there and have it witnessed and signed again. So as long as you are what we call of sound mind, then you can have a new will. Now, I often get asked about children, and they say, do I have to leave $1 to each child? Now, that used to be the way that you would show objects of your bounty. That was the official term. Objects of your bounty would include your children. Okay, no, you don't have to leave them $1. What the attorney will recommend that you do is that you recognize that you have 3 children. We've got Maddie, we've got Eric, and we've got Melina. Okay, maybe the situation is Maddie and Melina have already received gifts during life to maybe help them buy a home, start a business, whatever. And it was always to be clear that they would not take under the will. So the attorney will put that in the will to make it very clear that they are not to inherit, and not because you don't like them, but it's, look, in this case, they've already received monetary gifts. And then there's this dad's will. He says, to my son, I leave the pleasure of earning a living. For 25 years, he thought the pleasure was mine. He was mistaken. That one usually gets a laugh. So I'd like to think of you out there laughing. How about adopted children? Yes, they have the same rights as your biological children do, and that applies to grandparents. When your children have adopted children, those are considered as your lineal descendants. And then I had Heine here, Heinrich Heine, as I call him, and he made his wife the sole beneficiary on the condition that she remarry, because then there will be at least one man to regret my death. That's another one that usually draws a laugh. But let's take a look at a family situation here with John. And he has a will, and he has bequeathed $150,000 of his estate to his wife, Millie. There's just one problem. They're divorced. So I bet you can tell what I'm going to ask. You can anticipate. John dies. Who is going to get his property? Is it going to be Millie, his former wife, as mentioned in the will, or Sarah, his present wife? Is it his 3 children, or will it be John's parents? So we've got a divorce situation. We have a will naming Millie, his former wife, to inherit the property. So tell me with your click on the answer, please. Yeah, I'm really going to be interested in your response to this one. Okay. Well, we've got 44% that are saying it's Millie's former wife. We've got some of you that gave it to Sarah, and we only have 9%, 3 of you today, that said it was John's 3 children. So let's take a look and see what Montana law is going to do with this. Well, here's the deal. Millie is not going to inherit the property. I know that's what the will said, but Montana passed a law that said in the case of a divorce, any revocable instrument means that just goes away. And Sarah, his present wife, does not inherit as well. What they do is leave the property to his 3 children equally. Now, there would be an exception to this. Let's say that when they got divorced, John and Millie were still friends. and maybe even the court required some insurance. So what you have to do is make sure that that beneficiary designation occurs after, if we've got life insurance, or the will is after. Okay, so that then would allow Millie to inherit that $150,000. So again, it's because of the divorce, and we have a statute that says Millie cannot receive it. Okay, so it's definitely a divorce in the case of a former spouse, unless we date the will or the life insurance beneficiary designation after. Now, a separation decree, that is not what we call a divorce in Montana, so it's still good. So I want you to write a will to ensure your wishes are honored and you're not the bane of someone's existence. Now here I've got a fairy slipper that's kind of weird looking because it's white, and I call it an albino. And this is just to show you what it would look like normally. So it was very exciting to find that white albino fairy slipper. So let's look at the albino family in the early 90s. We've got mom and dad, they've got kids, they've got grandkids, and we just want to see what happens here. You see, the will says by right of representation. See, when mom dies, she's the last one. She says, I want this to go to my lineal descendant by right of representation. So I have the grandchild deed there. And what I want to know is what fraction, if any, will that grandchild receive? So the will states by right of representation. What fraction will that grandchild receive? Is it going to be nothing, 1/6, 1/8, or 1/9? Don't forget to hit the submit button. Okay, Emily, we got enough in that we can do a quick find out. Okay, we've got 6% that said nothing. We had 24% that said a 6. We had 6% that said an 8, and only 9% that said a 9. Okay, let's see what we've got here. The answer is going to be a 9, because what happens under right of representation in a will is we first look at how many children did mom and dad have, and they had 3. So therefore, it's going to be a third, a third, and a third. So we've got one grandchild here, the turquoise one, that receives a grandchild, because that is the share the dad would have received. Now, the 2 pink grandchildren don't inherit anything because their dad received by right of representation the third. And then the daughter, because she was deceased, her third goes equal, we split it equally. So we take a third, and that winds up a 9. And that's why we've got the division like that. So how you word it is very important. And I'm saying Montanans need to understand the meaning of right of representation when used in a will. And if you need a refresher on that, go back to our session that we had on dying without a will in Montana, and you can go through and see that at your leisure. Now, what we've got here is a heart-leafed arnica. And Emily, I think you're going to tell us the story about the Hart family.
Yes, so when we talk about the Hart family, we've got Joe Hart and Brooke Hart, and we'll talk about some heart-to-heart legacy planning that they've done. I think you'll have to click me forward, Marcia.
Okay.
So, Joe has heartfelt intentions, and he's got a $100,000 CD, and on that CD, he's designated Brooke, who is his sweetheart, as his payable on death beneficiary. But later, Joe changes his heartfelt intention and decides he wants that $100,000 CD to go to his son. So he writes a will that says, I bequest my $100,000 CD to my son, Eric Hart. So the question then is, who gets the $100,000? We have Brooke, who's listed as the POD beneficiary, or we have Eric, who was named in the will that was written most recently. Okay, looks like we have most of our answers in. So we have most people, about 60%, saying that Brooke ends up as the one with the CD because she's listed as the beneficiary, and about 18% believe that Eric will get it in the will that was most recently written. And Brooke is the correct answer. And we talked about this a few weeks ago when we talked about designating beneficiaries, but the reason is because a payable on death designation is a contract, and a will cannot undo a contract. So even though Joe wanted to change his mind, Brooke still ended up with the CD because he just wrote it in a will instead of changing the beneficiary designation. So if he wanted to change the recipient of that $100,000 to his son, he would need to go to the bank and fill out a new payable on death beneficiary designation form. Just remember, if you remember anything from this portion of the presentation, that you cannot undo a POD beneficiary designation or any other type of contract with a will. So when thinking about the Heartleaf Arnica, remember that like Joe Hart and Brooke Hart, have a heart, review your beneficiary designations on anything that might have them, including checking accounts, savings accounts, MSAs, CDs, and it's also important to review beneficiary designations on things like insurance as well.
Okay, well, the observation from the Lady Slipper is, once again, time has slipped away. My, how 30 minutes can go fast, and I hope it was for you as well. I hope we did steer you to do some consideration about how you're going to divide your assets, whether they be equally or equitably, and then just some of the things that you can do with a will and not do with a will, so that you're aware of that when you update your will. And if you don't have a memory like this elephant's head, we've got now 44 different topics that have to do with estate planning alone. We also have others on financial management, a wide variety of topics. And don't forget that these mock guides are also available from your county extension offices. And it looks like we're going to be opening up here in the next few weeks with some of those resources. We encourage you to look forward, or at least I'm looking forward to sharing with you some information about trust next week. We get lots of questions about trust. So I'm calling this session 101, Trust 101. And Emily and I would like to thank you again for joining us to learn a little bit about wills today. And we look forward to seeing you next week. But Emily, I think we've got some things we'd like for them to share with us, don't we?
Yes, we do. And if you want to click to the end of the slideshow, I'll open that up. You can stop sharing if you want so they can see your video more clearly. Because I don't know if it'll let you stop sharing if I open the poll. Okay. So right now I'm opening up an evaluation. We just like to have some of your feedback about what you think about the seminar, things that you learned, if you have any ideas about actions you can take. The other thing you'll notice is that the first question asks for you to type your email address if you would like to receive reminders about these webinars each week. If we already have your email address, you don't need to share it again, but you certainly can. It's pretty easy for us to sort through ones that we already have. Because I did notice that there was a couple people who mentioned in the chat that it's a little bit difficult sometimes to find the webinars if they're trying to navigate from a calendar or something. So if we have your email address, each Monday you will be sent a link directly to join the meeting, and you don't have to worry about finding the right one. So that poll will stay open for a little bit. And in the meantime, Marcia, do you want to answer some of the questions that come up?
Yeah, and I might just throw out, we did have a question last time from an individual that left an email. So if you are the individual that had a question about mobile homes, I sent an answer, but it bounced back. And Emily went and checked, and it just looks like there's something wrong with the email. So if that individual with the mobile home is on today, if you would give us your email again and say, hey, I'm the mobile home owner, then I'll get that answer to you. All righty. What kind of questions do we have that maybe I know the answer to, or maybe I don't?
So one of the questions is, what if a couple marries after already having created a will? So their own wills state their individual wishes and neither acknowledges the spouse. Do they recreate the will or do a codicil?
Okay, this is probably one of those situations where that almost everybody would say when you get married, when somebody dies, and there's other examples, that it's time to do a new will. Because quite frankly, if you're not careful, those wills won't recognize the other, and then you're disinheriting the spouse. And Montana will not let you do that. I mean, Montana has some rules. It's 3 pages in the law about what is called the augmented estate. And this is looking at what he has, what she has, and then, it's only in a case of disinheritance would that be true. So it wouldn't hurt. Take a look at doing a will that recognizes your marital state, and then you can still have property going off. But this way you're looking at, unless you have everything in joint tenancy. So don't forget the impact of property ownership on that as well. So it may be time to get a new will written.
Okay. So another question came up about the situation with Millie and Sarah, as Millie being the ex-wife and Sarah being the current wife. Would Sarah have inherited anything if she had been married to the husband for longer? Right? We had the situation where because he had named his former wife in the will, everything went to the children and Sarah didn't get anything. Is there a period of time that she could have been married for that she would have inherited at least something from that?
No, once there's a divorce, a former spouse just doesn't inherit unless we want to give part of that. And I was using like 150,000, and we could have pretended he was a millionaire, and so he was still leaving some to a former spouse. But he and the attorney, when they got the divorce, it would have been a really good idea to say, hey, let's make sure that this is really clear. Now, I may have some people that would object to that and talk about insurance. Well, there was a period of time where if you named a former spouse in your insurance, for example, that's the person that got it. And it was really bad because you would have, here he is, he's got 3 kids now, and his former spouse from, 20 years ago is inheriting the property. So that's why the legislature went in and changed that law. And I believe it was about 10 or so years ago that was done. So in a divorce, that just stops that former spouse from inheriting property, but not a separation decree.
I think that I maybe misphrased the question. So in that situation, Millie doesn't inherit anything because she's the former spouse, but Sarah, the current spouse, also didn't inherit anything. Why is that?
Okay, I see. That's where I should have said that there's actually $2 million there. And all he was leaving to his former spouse was 150,000. If that was the total estate, no, it wouldn't have all gone to the children. Part of it would have recognized the number of years that John and Sarah had been married.
Okay.
And so she could come in and say, I want, if we've been married more than 15 years, she would be entitled to half of that.
Okay.
So you probably said it right and I misunderstood.
Oh, that's good. Lots of good information. Another question. Pull up this other one here. Would a handwritten will that asks for revocation of a previous will be acceptable? So if you handwrite a will that says, I revoke my previous will, is that legal?
Now, that is a situation where it's going to be up to the district judge. And it could be that district judge, and you've done everything right in the handwritten will, would say, we hereby revoke. But given the situations that I've heard, it wouldn't be a good idea to go to an attorney or get it typed up and have it, notice I'm using the term typed, but keyboarded, whatever, so that you've got it.
Okay. So then another question, how is a handwritten will validated for soundness of mind?
That's one of the things that when you go to have a will written, the attorney is going to have two witnesses there. So you're going to be in a room, a table, and there will be some witnesses, and then there will be also probably a notary. And what the attorney will do is say, this is your will, and you acknowledge that it's your will, and it's your last wishes. And the attorney has that sense of, are you of sound mind in that particular case? And the same way with the witnesses. And they'll carry on a conversation about the day, whatever it is. And that's where I really messed up the very first time I had my will signed, because what I was doing is reacting. Well, I was nervous and I hadn't had a will written before. And so I was just and I was behaving inappropriately. And the attorney said, Marcia, these people are here to determine if you're sound mind. And the way you're acting is not giving them a lot of confidence. And he was partially kidding, but his point was, this is a solemn occasion and it's not the time to be joking around. So the neat thing about having the two witnesses and then having it notarized, so the person that is the notary will have the signature on there. And we call that then the will has been self-proven. It's self-proven that you're of sound mind. So in that case, when you die, there won't be the need to have those witnesses come into court and say whether or not you're of sound mind. Now, there are situations where some families are so contentious that the attorneys, even here in Montana, are videotaping the signing of the will, just to show the court, it's very obvious this person was of sound mind.
Okay, so then let's say that it's a holographic will. What happens because that wasn't written in the presence of witnesses, it wasn't signed in the presence of witnesses? How do they determine sound mind then?
And that's going to be the judge. The district judge. We don't have what's called a probate judge in Montana. It will be the district judge that will make the determination about that will and say it's either valid or it isn't. And in some cases, if there's not a big family hoorah about the whole thing, is even the clerk and recorder can look at all this stuff and say, oh, I think, there's not going to be a formal probate. Everything's going to be informal, but it will still be the district judge that will put his or her stamp on that and accept the validity of the will.
Okay. So another question. In the event that somebody doesn't have children, how would nieces and nephews be considered? Let's say that you maybe right of representation in the will, but you don't have children, but you have nieces and nephews. What happens if you die without specifically naming them in the will?
Okay, it's not necessary to actually, well, there's a couple of ways to do it, because you may have nieces and nephews and say, okay, those are the ones you're going to have, and so you name them. But if you want to provide for another niece or another nephew that may be born, later after your will was written, the attorney is going to write some language in there to the effect that those would be recognized along with the rest, depending on if you're trying to do equal. And then if you're doing the right of representation, you got to remember, okay, are you totally going to the nieces and nephews, or are you going to go to the parents first? And if you want to ignore the parents and just do the nieces and nephews, keep in mind, you may live to be 90 or 95, and it could be those nieces and nephews would get married and would have children, and perhaps one of them would predecease you. And okay, does the will take care of that? So go back to that Dying Without a Will session, and you can see where it goes, or utilize our Mont guide that we have on that topic as well.
Okay. A one question that came up asked, do you recommend using a software program like Quicken's Willmaker Plus?
Oh boy. Do I recommend? No, in my position, I cannot recommend something like that. I can say if you go and you have one of those kits, and I know some of them are very good because they have a book with it and it describes everything so that you really understand it. But for me, it'd be like trying to do my own plumbing. I'm going to call a plumber. And for a will, I'm going to go to an attorney. And I've done that because they bring up things every time I think I'm smart as can be, they'll bring up something I hadn't thought about. So that's why I want to pay for some legal advice. Yeah.
Okay. Another question that came up, where can we find estate planning info for other states? So if they're out of state, the same laws may not apply. Where do they find that information?
Yeah, that's true. I would suggest that you contact the extension service in that state. Almost every state has somebody in extension that does work in the area that I'm in. It may be a state specialist, it could be an area specialist, or it could be somebody that is in the ag econ department, sort of like I am. And just Google extension and for that particular state, and they will take you to the land grant university. And then in the search engine that they have, you can put estate planning, and you'd be surprised. Illinois, North Dakota, South Dakota, Wyoming, almost everybody around us has some information.
Okay. Another question, would it be necessary or helpful to mention the beneficiary deed on my townhome when I revise my will?
Um, yeah, because you've got a transfer on death deed, and that's going to go outside the will. But the reason you still want the will is just in case you forgot something else. Okay. And the will then would acknowledge, it's not that you have to, but it would acknowledge, oh, that's something they didn't know about. Your personal representative that you nominated in your will didn't know that this land existed. So, oh, there it is in the will that indicates that you are passing that outside of probate by the use of a transfer on death deed.
Okay. We had just an input from one of our participants too, who said that the question about information in other states, that your local agency or council on aging can be a good resource for estate planning as well.
Yes, that's excellent. Yeah. And many state bars also provide some basic information. So if you would just Google, State Bar of Idaho or State Bar of Wyoming, you would find that some of them do.
Okay. Another question that came up, is there a statute of limitations for contesting a will? Let's say 5, 8 years ago.
Okay. Wow. If a probate has already been closed and the will declared valid, you're going to have a difficult time opening that up. Now, if there's a situation about fraud, then it can be. And, we don't really have a statute that I'm aware of. So that would be something for me to check on a little bit more. But anytime there's a fraud, you can go back. But the trouble with that is the estate was closed 8 years ago, and it's been distributed out. And it's going to be very challenging to go back and do that. Now, I've also been aware of situations where a probate was never held. Somebody died 8 years ago, and now they're trying to go in and get that figured out, and who has died since that time. I mean, wow, that could be a real mess. But sometimes it happens. People just didn't know. Oh, the children were out of state. Maybe they were estranged, and so died, and woof, there wasn't a probate that was held. And that was a real problem in eastern Montana when they started all this mineral interest situation. They weren't even back in the old days probating mineral interests. So they had to go back in some cases to the 50s and find out who wound up, 50 years later owning property or owning this mineral rights. And that was, I got several calls about that at the time. So take care of it. Make sure that somebody in the family gets that probate started if it's necessary.
Okay. I don't see any more of those questions for now. If you have any more, please feel free to type them in or anything we can clarify. Some just sort of logistical ones that came up. Someone asked if the seminars are going to continue online when the state opens back up. And the answer is, for the seminars we have planned, yes, we are going to continue offering those online so that you can attend from anywhere in the state or really anywhere in the country. I believe we have those planned through the second or third week of June, right, Marcia?
Mm-hmm.
Yep. Another question that came up is there a way to view the past recordings of Tuesday Tips? And yes, there is. We have a YouTube channel through MSU that those are uploaded to, and I put the link for that in the chat box if you want to take a look at it. Usually we get the previous recordings up within the next 2 to 3 days. It just depends because they're large videos. They sometimes take a while to upload, but we usually have those up by the end of the week. So yeah, feel free to go back and watch those anytime you want. And again, if you want to join the Tuesday Tips each week, probably the easiest way to do that, if you're not receiving email reminders, is to just go to the Tuesday Tips website, which you can get to by typing in montana.edu/estate planning. And there's a Tuesday Tips section at the top of that page. And if you click there, there's a nice big button that says Join Webinar, and you can click on that every week and it'll take you right to this meeting. So I haven't seen any more questions come up. Marcia, is there anything else you want to add?
Nope, just thanks again for joining us, and we look forward to seeing you next week where we're going to find out what we can about trusts.